Robert Downey Jr. was 30 seconds away from humiliating one of America's most powerful judges with a single legal argument that would change intellectual property law forever. Judge Brett Kavanaugh thought he was facing just another Hollywood actor desperate to protect his Marvel millions. He had no idea that the man standing before him had secretly spent 15 years mastering patent law, trademark protection, and constitutional intellectual property rights with an expertise that would leave seasoned IP attorneys speechless. "Your Honor," said RDJ, his voice carrying the same confidence that had made Tony Stark legendary. "In the next 60 seconds, I'm going to prove that Marvel's licensing practices violate constitutional commerce principles in ways that will shock this entire courtroom. What happened next would revolutionize both entertainment law and intellectual property protection forever." Before we dive into this extraordinary fictional legal confrontation, smash that like button and subscribe for more incredible stories of hidden genius challenging the most powerful authorities in America. Kavanaugh's World, corporate-friendly authority, Judge Brett Michael. Kavanaugh represented the establishment corporate legal order. At 59, the Supreme Court justice had built his reputation on business-friendly rulings and strong protection of corporate intellectual property rights. A Yale law graduate with extensive corporate law experience, Kavanaugh embodied traditional judicial approaches favoring large corporation interests over individual creative rights. His judicial philosophy emphasized protecting established business models and limiting challenges to corporate IP practices. Kavanaugh particularly supported entertainment industry giants and viewed celebrity legal challenges as frivolous attempts to renegotiate commercially beneficial contracts. That day, his assumptions about Robert Downey Jr. were predictable. Yes, RDJ was extraordinarily successful as Iron Man. Yes, he had negotiated unprecedented Marvel contracts. But in Kavanaugh's view, he was simply another actor using legal theatrics to extract more money from legitimate business arrangements. This assessment would prove to be catastrophically wrong. RDJ's hidden journey, from recovery to legal mastery. The world knew Robert Downey Jr. through his incredible comeback story in Marvel dominance. From personal struggles to becoming Iron Man, his transformation had made him one of Hollywood's most compelling figures. With Marvel earnings exceeding $500 million in producer credits across multiple franchises, RDJ had redefined celebrity business power. But what the public didn't know was that RDJ's business acumen had been built on intensive study of intellectual property law and constitutional commerce principles. Starting in 2008, inspired by his Marvel contract negotiations and determined to understand the legal frameworks governing creative ownership, RDJ had begun serious study of patent law and IP protection. The entertainment industry operates on intellectual property that creators rarely truly own, he had confided to his wife Susan during one of their strategy discussions. "If I'm going to protect my creative legacy and help other artists, I need to understand the constitutional principles that should govern these arrangements." Working with IP law professors from Stanford and USC, RDJ spent his time between filming, studying Supreme Court patent precedents, trademark law, and the constitutional foundations of intellectual property protection. He completed advanced coursework in IP law, constitutional interpretation, and the intersection of creative rights with business law. By 2023, when the case that would bring him to federal court emerged, RDJ wasn't just defending his Marvel fortune. He was also a well-educated advocate for constitutional IP rights with genuine expertise in the intellectual property law that governed creative industries and character ownership. The Case Foundation: Creative Ownership versus Corporate Control. The federal case that brought Robert Downey Jr. before Judge Kavanaugh represented one of the most significant intellectual property challenges in entertainment history. Downey Jr. v. Marvel Entertainment challenged the studio's character ownership practices as violations of both constitutional commerce principles and federal antitrust law. The case had emerged when RDJ filed a comprehensive lawsuit claiming that Marvel's exclusive character ownership arrangements violated constitutional principles by permanently separating creators from characters they had developed and embodied. He argued that entertainment IP practices created illegal monopolies over creative expression that exceeded constitutional commerce authority. The implications extended far beyond RDJ's situation. If his legal theory prevailed, it would fundamentally reshape entertainment IP law and establish new constitutional protections for creative professionals who developed characters through performance. If Marvel won, it would confirm that studios could maintain absolute character ownership without constitutional constraint. For Kavanaugh, this case represented an opportunity to defend established IP practices while protecting corporate investment. He viewed it as a matter of upholding legitimate business arrangements against actor demands for character ownership rights. For RDJ, the case was about fundamental constitutional principles. Whether the Commerce Clause protected creative professionals' connection to characters they developed, and whether entertainment IP practices could constitutionally separate performers from their creative contributions permanently. The setting: Los Angeles Federal District Court. The modern courtroom of the U.S. District Court for the Central District of California was packed with entertainment lawyers, IP specialists, and industry executives. This case had drawn global attention both because of RDJ's status as Iron Man and its potential impact on character ownership and IP law. At the plaintiff's table sat Robert Downey Jr., dressed in a sharp charcoal suit that projected legal seriousness rather than Hollywood glamour. His legal team from top IP firms flanked him, though RDJ had insisted on presenting key constitutional arguments himself, a decision that had surprised intellectual property experts. At the defense table, Marvel Entertainment had assembled their most experienced IP attorneys, led by Chief Legal Officer Patricia Wong, a Harvard law graduate with decades of experience in entertainment IP litigation. Behind them sat Disney executives and industry representatives, all confident this would establish important precedents protecting studio character ownership. Judge Kavanaugh, presiding over this case due to its significance for IP law, had already made his corporate-friendly approach clear through his previous entertainment industry rulings. First contact: the dismissive challenge. Mr. Downey, Judge Kavanaugh began, his voice carrying the authority of federal IP jurisprudence, this court recognizes your commercial success as Iron Man and your business acumen. However, intellectual property law involves established constitutional principles and sophisticated corporate ownership frameworks. Are you prepared to engage seriously with IP doctrine rather than asserting emotional claims about character connection? The question was designed to highlight what Kavanaugh saw as the fundamental difference between performance success and legal expertise. His tone suggested he expected RDJ to rely on his legal team or demonstrate the kind of IP superficiality he associated with celebrity business litigation. RDJ stood deliberately, his posture respectful but confident. Your Honor, I understand your concern about respecting established IP law. However, I'd like to address that concern by discussing the Supreme Court's analysis in Graham vs. John Deere Company and how patent law principles apply to character development and creative contribution. A surprised murmur went through the courtroom. This wasn't the celebrity IP dispute Kavanaugh had expected. The Patent Act, RDJ continued, protects innovation and creative contribution, not just initial conception. When an actor transforms a character through performance innovation, they create patentable creative contributions that deserve constitutional protection under IP law. Kavanaugh's expression shifted slightly. The response demonstrated actual understanding of constitutional IP law, not just entertainment industry talking points. Testing the constitutional waters. Mr. Downey, Kavanaugh continued, his tone becoming more serious. Citing patent precedents is one thing. Understanding how modern IP law balances creator rights against corporate investment is quite another. Are you familiar with how contemporary intellectual property law evaluates ownership claims in collaborative creative projects? This was the kind of question designed to separate constitutional amateurs from serious IP practitioners. RDJ nodded confidently. Absolutely, Your Honor. The court's framework in eBay Inc. v. Merck Exchange establishes that IP protection must serve constitutional purposes of promoting innovation rather than simply protecting investment. When character ownership practices suppress creative innovation, they exceed constitutional IP bounds. Kavanaugh leaned forward, his interest clearly piqued. Continue with your constitutional analysis. Marti. Marvel's character ownership practices, RDJ proceeded, violate this constitutional framework because they claim permanent ownership over character innovations that performers created through their creative contributions. This suppresses rather than promotes the innovation that IP law exists to protect. The courtroom had grown quiet. Entertainment reporters were taking detailed notes, and even Marvel's attorneys were paying close attention to this unexpected constitutional discourse. The revelation, RDJ's IP law expertise. Mr. Downey, Kavanaugh said, his tone now markedly different from his initial dismissiveness, your constitutional analysis of IP law demonstrates considerable legal sophistication. Where did you develop this expertise in patent law and constitutional intellectual property? RDJ's response would reveal the depth of his legal preparation. Your Honor, I've spent 15 years studying intellectual property law and constitutional commerce, initially through Stanford Law's IP program, later through private study with constitutional scholars specializing in patent law and creative industry regulation. I've worked directly with Professor Mark Lemley at Stanford on patent innovation theory, studied under Professor Rebecca Eisenberg at Michigan on IP constitutional principles, and completed advanced coursework through USC's entertainment law program, focusing specifically on the intersection of performance, character development, and constitutional IP protection. The courtroom buzzed with surprise. Kavanaugh himself looked genuinely taken aback. Moreover, RDJ continued, my practical experience developing the Iron Man character through performance innovation has given me unique insight into how IP law affects creative collaboration. I've seen firsthand how current ownership practices stifle rather than promote creative innovation. Kavanaugh's deeper constitutional challenge. Kavanaugh, now taking RDJ's arguments seriously, decided to test the deepest level of his constitutional understanding. Mr. Downey, your case essentially argues that performance contributions deserve IP protection equal to character conception. But how do you address the legitimate investment interests that justify exclusive character ownership arrangements? RDJ's answer would demonstrate whether he truly understood the complexities of constitutional law in the IP context. Your Honor, there's a crucial distinction between protecting legitimate investment in creative projects, which the Constitution supports, and claiming permanent ownership over creative innovations that performers contribute through their artistic work, which exceeds constitutional IP purposes. He paused to organize his constitutional argument. The Supreme Court's decision in Bonito Boats v. Thundercraft Boats established that IP protection must balance innovation incentives with creative freedom. When character ownership suppresses performer innovation, it violates this constitutional balance. Kavanaugh was now fully engaged with RDJ's constitutional analysis. You're arguing that performers can acquire IP rights through creative contribution. I'm arguing that when performers make substantial creative contributions to character development, voice, mannerisms, emotional depth, character evolution, these contributions deserve constitutional IP protection regardless of initial ownership arrangements, RDJ responded. The Precedent Analysis, Building Creative IP Framework. Moreover, RDJ continued, we have direct precedent for protecting creative contributions in collaborative projects. The Supreme Court's decision in Community for Creative Nonviolence v. Reed established that creative contributors can acquire rights in collaborative works based on their contributions, not just initial conception. Kavanaugh was taking careful notes. How does Reed apply to character performance? Reed's constitutional principle applies directly to character development, RDJ replied. When performers make creative contributions that transform characters, as I did with Tony Stark, these contributions deserve IP protection because they constitute innovation that IP law exists to promote. RDJ then presented his most sophisticated constitutional argument. The court's recent decision in Alice Corp. v. CLS Bank confirms that IP protection must serve innovation rather than simply protecting abstract ownership claims. Character ownership that suppresses performer innovation violates this constitutional requirement. Kavanaugh's constitutional recognition. The change in Judge Kavanaugh was evident to everyone in the courtroom. His initial skepticism had evolved into genuine engagement with RDJ's constitutional arguments. "Mr. Downey," Kavanaugh said, "I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented IP arguments that merit serious consideration from this court." "Thank you, Your Honor," RDJ responded. "I hope this demonstrates that constitutional IP principles should protect creative innovation regardless of who contributes it. The Constitution exists to promote creativity, not suppress it through permanent ownership arrangements." Kavanaugh nodded thoughtfully. "Your argument essentially contends that IP law must evolve to protect performer contributions in character development. This raises fundamental questions about the nature of creative ownership in collaborative entertainment projects." The landmark decision Judge Kavanaugh ultimately ruled that while traditional character ownership remained valid, performers who made substantial creative contributions deserved constitutional IP protections that couldn't be permanently waived through contracts. The decision established new precedents for collaborative creative rights. The cultural impact. The RDJ v. Marvel decision revolutionized entertainment law and sparked global conversation about creative ownership and performer rights. Law schools began studying RDJ's constitutional arguments, and the case became a landmark precedent for IP law. RDJ's legacy. Robert Downey Jr. had proven that constitutional expertise could emerge from creative experience and that protecting creative rights required the same intellectual rigor that had made him a successful actor and businessman. If you found this incredible fictional story of creative constitutional courage and hidden IP brilliance inspiring, smash that like button and subscribe for more amazing tales of unexpected expertise challenging the most powerful authorities. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and creative innovation can combine to protect artists' rights. What did you think of this fictional portrayal of RDJ's constitutional expertise? Drop your thoughts in the comments below. Important note: this is completely fictional entertainment content. Any resemblance to real events or persons is purely coincidental.